Hey guys, what if I show you a way to claim monies back from the credit providers? And today I'm going to talk about the In-Duplum rule. In-Duplum, what does that mean to you as a consumer? Well, there's two different types of In-Duplum: common law and the National Credit Act In-Duplum. I'm going to talk about the National Credit Act In-Duplum. In 101 and 103.5 of the National Credit Act, it spells it out what In-Duplum is. I will be simplifying it in the next slide and break it down to basics. Now, credit providers do not follow In-Duplum. They hand over information to debt collectors, debt collecting attorneys, and even themselves by loading extra fees, cost, interest, credit life, and it even hampers your credit report, because a lot of times on the credit report your information is inflated, showed unpaid balances due to the negligence of these credit providers, the banks, the microlenders. Most of these guys do not act in good faith. They're more interested in see how they can prejudice the consumer and not worried about what it says in section 3, the purpose of the act. Here is an example. A consumer borrowed 1,000 from a creditor. The consumer defaulted on his payments, and at the date of default, the balance of his account was 800 Rand. According to the In-Duplum rule, that collectible balance on this account cannot exceed 1,600 Rand, fees, cost, legal fees, and interest. I'll put a couple of slides together on accounts of which has reached In-Duplum. Let's start with the first account. Let's start with the first loan. The loan was given to this consumer of 45,140 Rand. Interest of 27,658 Rand. Credit life was added for the term of loan of 4,950. This is supposed to be deducted monthly as set out in 106 of the National Credit Act, which brings in the total balance of 73,877. What's interesting about this case, when the consumer defaulted in the second month, it was handed over to a debt collecting attorney where further interest was charged of 59,368 Rand, which added additional credit life assurance on top of the outstanding balance, which brings the total to 131,798 Rand. The default was round about 45,000, times that by 2 is 90,000 Rand. But the credit provider overcharged the client more than 40,000 Rand. Therefore, there could be a refund back to this consumer. Loan 2. What I found quite interesting with this one was an overdraft facility. This was from a particular bank. In 2008, the client came to see us, and when we called for the outstanding balance, it stood at 75,000 Rand. The interest was 446 Rand, and the credit life only 138 Rand. In 2018, when we requested outstanding balances, we found that the outstanding balance increased to 260,000 Rand, the interest increased to 3,420 Rand, but she was making payments since 2008 of 911 Rand. What was disturbing Even the credit life went up to close to 2,800 Rand, which added back to the outstanding balance. More interest and costs were charged, and In-Duplum was reached by nearly 3 times. We investigated the statement, took it up with the bank. We got then 166,000 Rand refunded, requested by the bank to look at the interest, and another 40,000 Rand was paid back to the client, which made this client debt-free. Loan 3 is my own account. This is a statement from the bank. The credit card was at 0%. This credit card was backed by a medical aid. My outstanding balance at that stage was 3,464 Rand. I then paid in 500 Rand. The reason for my default is the medical aid cancelled this credit card by means of a newsletter. They didn't even follow the procedures of the National Credit Act by notifying me by means of email or post. My medical aid never paid my doctor's accounts, which put me in default, and I said to them I'm going to refuse to pay this because they never followed the spirit of the Act. The certificate of balance, which was signed off by the CEO at that stage, was 6,949 Rand. I worked the system for 3 years to get this account prescribed. The credit provider, or this bank, then added additional interest where I signed for 0%. They pushed the interest rate up to 22.1%. Now, the credit provider, or this bank, couldn't give me my original contracts. They said it got lost. Now, I found it quite strange, a big bank like this losing documents. But hang on, everything was done on a voice recording. So with the technological world we're living in, you're safe as your accounts with these banks if they can lose your information, even if it's done by means of voice recording. This account was then handed over to an attorney, and the handover amount was 6,949 Rand. The attorney then carried on charging interest of 22.1%, additional charges, take instruction fees, emails, and everything was added back to the main account. Remember, in my second slide I spoke about interest, fees, cost, and interest or legal fee interest cannot be more than double of the handover amount. But what made it even worse on this specific statement is that the bank paid in additional 500 Rand into my account. They couldn't tell me where this 500 Rand came from. I then worked out that the bank paid into this account to stop prescription taking place. So consumers, it's very important to investigate your statements. That the fraud that takes place by the banks and credit providers of stopping prescription and additional fees being charged. You have the right to choose. As you'll see, when I called for the final statement, my total went up to 10,000 Rand from 3,000. It's nearly 4 times that amount. I then took on the CEOs. I put everything onto a PowerPoint, showed them the mistakes using the National Credit Act in my favor, and the two CEOs sent me a letter, says account cancel, regards the bank. Nobody was prepared to put their name on the cancellation letter. Very sad. This is quite an interesting one. This account has not reached In-Duplum, but I thought I'll bring this slide in as this is one of my retail accounts. My outstanding balance at this stage was 657 Rand. I defaulted on purpose, and the reason why I put myself into default is working in the credit industry. The retailers and banks don't want to give a third party any information. So the only way to prove my theory is to put myself into default. The opening balance was 657 Rand. They then start phoning me because I never paid this account. SMSs were sent, a collection letter was sent, phone calls, emails, phone calls, SMSs, and so the process goes forward. I then requested the information from this retailer. I also requested the Council of Debt Collecting certificate. The retailer said to me they don't have to be registered with the Council of Debt Collectors. I phoned the Council of Debt Collectors and they said anybody collecting on debt must be registered. I also looked in the Magistrates Court Act, Section 60. Only a debt collector and a debt collecting attorney can collect on debt, and they have to follow the procedures that's set out in the National Credit Act, as well as the Council of Debt Collectors Act and the Magistrates Court Act. Now, the reason I'm bringing this to your attention is my fees went up to nearly 200 Rand. So from 657 Rand, it went over 800 Rand. Now, if this account gets handed over to a debt collector, the debt collector is not the wiser because he's now charging additional fees, and there's only limits under the Council of Debt Collectors. The debt collector is committing an offence of not investigating the statements correctly. The retailer does not care because everything gets done on a CSV file, on an Excel spreadsheet. So when you investigate your statements, make sure that the debt collectors are registered, the retailers are following the procedures of the National Credit Act, and that you've not been overcharged and the accounts has not reached In-Duplum. Most credit providers are not acting in good faith. When you receive a summons, always request from the attorney the original contracts, a statement from inception, because most of the summonses is incorrect, as attorneys receive documentation by means of an Excel spreadsheet on handover balances or as a CSV file. They just work on instruction and presume everything is correct which they receive from the creditors. They'll always put in their papers, we cannot locate the original contracts. But what I found quite strange, most credit cards and some retail accounts and some microlenders work on voice recordings. So how can documentation get lost? So by requesting a statement from inception, it gives you some form of guidance to see if this account has not reached In-Duplum, or accounts has been prescribed, and that the credit provider as well as attorney and the debt collector act in good faith. As you will see in Regulation 56, that the credit providers has to make sure they keep their records. But what I found quite strange, most of these credit providers don't even keep their records. They don't know how to store their records. Now, what I'd like to bring to your attention is that you as a consumer need to check your credit status. Make sure that the information on the credit bureau is done correctly, because of these slides which I showed you, how many accounts has been inflated on the credit bureau, showing default status on the credit bureau, and you cannot get further credit due to the negligence of the credit providers. There's 4 acts that helps you as a consumer: the National Credit Act, the Council of Debt Collectors Act, the Consumer Protection Act, and the Magistrates Court Act. Need assistance? Let's investigate your credit agreements. Call us on 082 828 1258. Make sure your credit status is correct. Challenge your credit report. Remember, there is life after debt.